Swayam Prabha. Digital India. Educated India.
Namaste. We move forward with our discussion on the Wildlife Protection Act. In the last lecture, we looked at the beginnings of the Wildlife Protection Act, the various definitions, and how sanctuaries are formed. Now, today we'll begin with the declaration of national parks. Now, we have seen before that sanctuaries and national parks both belong to the term protected areas. And protected areas, we saw, comprises of four things: sanctuaries, national parks, community reserves, and conservation reserves. Now, in this context, sanctuaries and national parks are very similar. Their process of notification is also very similar. The restrictions are also very similar, with one major difference, that in the case of a sanctuary, grazing is permitted, whereas in the case of national park, grazing is not permitted. So, how are national parks declared? Whenever it appears to the state government that an area, whether within a sanctuary or not, meaning that a sanctuary can also be upgraded to a national park, is by reason of its ecological, faunal, floral, geomorphological or zoological association or importance, needed to be constituted as a national park for the purpose of protecting, propagating or developing wildlife therein or its environment. It may by notification declare its intention to constitute such area as a national park. So, here as well we find an intention to constitute, that is the first stage. Provided that where any part of the territorial waters is proposed to be included in such national park, the provisions of section 26A shall, as far as may be, apply in relation to the declaration of a national park as they apply in relation to the declaration of a sanctuary. So, we had seen before that section 26A is about the final notification, and this paragraph is saying that this section 26A will also apply to the national parks if you have territorial waters. The notification referred to in subsection 1 shall define the limits of the area which is intended to be declared as a national park. So, as in the case of a sanctuary, the notification should tell the limits of the area. What is the area that is intended to be declared? Where any area is intended to be declared as a national park, the provisions of sections 19 to 26A, both inclusive, except clause C of subsection 2 of section 24, shall, as far as may be, apply to the investigation and determination of claims and extinguishment of rights in relation to any land in such area as they apply to the said matters in relation to any land in a sanctuary. So, we had seen before that sections 19 to 26A deal with the complete process, and in that process, first of all, the intention is notified, followed by an inquiry into the rights, and then taking up all the rights. So, the collector has the option of either procuring those rights through compensation or through the land acquisition code, or he may remove certain areas from the area that was earlier intended, so as not to infringe upon the rights of the people. So, everywhere we are finding that the rights of the people are paramount. Whenever we are talking about a sanctuary or a national park, the first thing, the foremost thing that you should keep in mind is that in any of these, the rights of the people are not impacted. The laws are made in such a manner. So, unless and until there is some fallacy, there is something that is not going correctly, only in those cases, if the law is not being followed, only in those cases will there be any infringement on the rights of the people, otherwise the rights are not impacted. And after all of these are done, after people have the option of appeal, only then is an area finally declared to be a sanctuary or a national park. And the same sections as were applying to a sanctuary are also applying in the case of a national park. And when the following events have occurred, namely the period for preferring claims has elapsed, and all claims, if any, made in relation to any land in an area intended to be declared as a national park have been disposed of by the state government, and all rights in respect of lands proposed to be included in the national park have become vested in the state government. So, the state government has to take in all the rights through the processes of compensation. The state government shall publish a notification specifying the limits of the area which shall be comprised within the national park, and declare that the said area shall be a national park on and from such date as may be specified in the notification. And no alteration in the boundaries of a national park by the state government shall be made except on a recommendation of the national board. Then it says, no person shall destroy, exploit or remove any wildlife, including forest produce, from a national park, or destroy or damage or divert the habitat of any wild animal by any act whatsoever, or divert, stop or enhance the flow of water into or outside the national park except under and in accordance with a permit granted by the Chief Wildlife Warden. And no such permit shall be granted unless the state government, being satisfied in consultation with the national board that such removal of wildlife from national park or the change in the flow of water into or outside the national park is necessary for the improvement and better management of wildlife therein, authorizes the issue of such permit. So, basically we have seen that a very similar language is used even in the case of the sanctuary. So, in the case of national park, if you need to remove or exploit any forest produce or make any changes into the habitat whatsoever, you require a permission from the Chief Wildlife Warden, and they should also have an okay from the state government and from the National Board of Wildlife. In the case of national parks, the National Board of Wildlife also plays a role. Provided that where the forest produce is removed from a national park, the same may be used for meeting the personal bona fide needs of the people living in and around the national park, and shall not be used for any commercial purpose. Now, why is this portion important? It is important to ensure that people do not divert the resources of national parks for commercial interests. So, even if the state government wants it, even if there is a felling of tree that has happened in the national park. So, for instance, at times we get attacks from insects such as the sal borer. So, if there is a massive attack by the sal borer and all the sal trees have been impacted by that attack, and so the government says that we need to fell these trees to contain the infection. So, when that happens, all the trees that have been removed will not be used for any commercial purpose. They can only be used for meeting the bona fide personal needs. So, personal bona fide needs of the people living in and around the national park, and not for any commercial purpose. So, this is again another safeguard that has been included in the act. No grazing of any livestock shall be permitted in a national park, and no livestock shall be allowed to enter therein except where such livestock is used as a vehicle by a person authorized to enter such national park. In the case of a sanctuary, we had seen that no livestock shall be permitted without immunization, but in the case of a national park, no livestock shall be permitted except when a livestock is being used as a vehicle only by an authorized person. And the provisions of sections 27 and 28, sections 30 to 32, and clauses A, B and C of section 33, section 33A, section 34 shall, as far as may be, apply in relation to a national park as they apply in relation to a sanctuary. So, everything else remains the same. And there is an explanation for the purposes of this section. In case of an area, whether within a sanctuary or not, where the rights have been extinguished and the land has become vested in the state government under any act or otherwise, such area may be notified by it by a notification as a national park, and the proceedings under sections 19 to 26 both inclusive, and the provisions of subsections 3 and 4 of this section shall not apply. Meaning that if you have an area that is whether within a sanctuary or not, but if the rights have already been extinguished and the land has become vested in the state government under any act. So, for example, we had seen that in the making of a reserved forest as well, the rights are inquired into by the forest settlement officer, the rights are settled, and all the rights are then vested in the state government. So, if that thing has happened, so if all the rights have been extinguished and the land has become vested in the state government, then we do not need to follow all these procedures because they have already been done. And in that case, the state government can directly declare the area as a national park. Then two other things for conservation reserve and community reserve in protected areas. So, declaration and management of a conservation reserve, here we see that it is section 36A. So, it was added later on, it was not there in the original act. The state government may, after having consultations with the local communities, declare any area owned by the government. The important thing here is that the area is owned by the government, but then too you need to have consultation with the local communities. The government cannot declare it one-sided. Particularly the areas adjacent to national parks and sanctuaries and those areas which link one protected area with another as a conservation reserve for protecting landscape, seascape, flora, fauna and their habitat. Provided that where the conservation reserve includes any land owned by the central government, its prior concurrence shall be obtained before making such declaration. So, the important thing here is what are the areas that you make into a conservation reserve? It has to be an area owned by the government. If it is owned by the central government, then prior concurrence of the central government is required. And we choose areas that are adjacent to the national parks and sanctuaries and areas which link one protected area with another. So, what do you mean by linking of an area with another area? It means that whenever we look at two protected areas, there is certain movement of animals that goes on between one protected area to another protected area. So, it is a natural process. So, for instance, you will find that tigers naturally move out of the protected areas because they have to establish their own territories. So, when they move from one forest area to another forest area, from one protected area to another protected area, they take a certain route, and that route is determined by the tiger by looking at the topography of that area, by looking at the water availability of the area, by looking at the amount of human interference that is going on in that area. So, typically tigers will prefer areas such as canals. So, if there is a canal, so in the dry season the tiger might make use of the canal to move from one protected area to another protected area, or a river stream, or say certain agricultural fields. Now, in these situations, we say that these are the areas that are linking one protected area to another protected area. Another term for these areas is also corridors. Now, in the case of such areas, if the government has a particular piece of land in that area, then the government can declare it to be a conservation reserve. The benefit would be that the tigers, when they are moving from one place to another, they also need to take a night halt somewhere. They also need to take rest somewhere. And if there is a conservation reserve in the nearby area where we manage the forest looking at the wildlife resources, ensuring that there is sufficient water, there is sufficient food and there is no disturbance for the tiger, then the tiger will naturally prefer to stay in that conservation reserve and not in the surrounding human dominated landscape like villages or agricultural fields. So, these areas become sort of stepping stone corridors. So, basically the tiger moves from one protected area to the next conservation reserve, to the next conservation reserve, to the next conservation reserve, and finally it enters its destination protected area. So, these areas can be converted into stepping stone corridors, and which is why we have this provision of areas linking one protected area with another, and these areas can be declared. Now, the provisions of subsection 2 of section 18, subsections 2, 3 and 4 of section 27, sections 30, 32 and clauses B and C of section 33 shall, as far as may be, apply in relation to a conservation reserve as they apply in relation to a sanctuary. So, other things are mostly the same. Now, in the case of a conservation reserve, we also have a conservation reserve management committee, and the objective of this committee is to advise the chief wildlife warden to conserve, manage, maintain the conservation reserve. Who are the members? It comprises of a representative of the Forest or Wildlife Department, who is also the member secretary of the committee, one representative of each village panchayat in whose jurisdiction the reserve is located. So, everywhere you will find that there is a say of the local people, because the local people are very much required, they are very important for doing any conservation activities. You have to keep them on your side. They have to be in the line of conservation, because only then, if there is any forest of or wildlife offense that is occurring, then these people are the eyes and ears of the department. If they are antagonized by any activity, if they consider that the wild animals are not their friends but their enemies, if they do not derive any benefits out of the wild animals, then it is possible that they might aid the poachers. And so, it is very crucial that they should have a say in all the matters relating to the protected areas in their jurisdiction. And which is why you will find that in this management committee, there is a representative of each village panchayat in whose jurisdiction the reserve is located. 3 representatives of NGOs working in the field of wildlife conservation, and 1 representative each from the Department of Agriculture and Animal Husbandry. And the committee shall regulate its own procedure, including the quorum. Then, similar to a conservation reserve, we also have a community reserve. The main difference is that in the case of a conservation reserve, it is a government land, whereas in the case of a community reserve, it is a privately owned land. So, if you have a piece of land, or if a village or a community has a piece of land, they can ask to get it declared as a community reserve. Now, why would somebody want to get their lands declared as a community reserve? Well, the primary objective is to earn money through things like tourism. So, you will find that in a large number of areas, the agricultural productivity is not very high. So, the agricultural productivity is low. Why? Because probably there is a large amount of soil erosion in that area, or the soils are not fertile, or there is a dearth of water. And in these areas, if the community is able to establish a protected area, then they can have an alternative source of livelihood in the form of tourism. So, they can start to work as guides, they can start to work as gypsy drivers, they can work in the hospitality sector. All these sectors come up when you have a protected area in the vicinity. The second objective could be that in the case of certain communities, they have a very strong wildlife conservation ethos in their culture. So, for example, if you talk about the Bishnoi community, the Bishnois are very much, they are very adamantly protective of the wildlife in their area. It's a part of their culture, it's a part of their way of life. So, you'll find that even if there are herbivores that are grazing in their fields, they do not kill those herbivores. Now, there can be certain communities where it is a part of their culture and they might want to have a community reserve because it's a part of their culture. So, this again, if you look at this section, it says 36C, which means that it was added later on based on the demands of different communities. So, when communities started to say that we want to have a protected area nearby, this section was included. So, the state government where the community or an individual has volunteered to conserve wildlife and its habitats. So, it is a voluntary activity here. It should come up from the individual or from the community. Declare any private or community land not comprised within a national park, sanctuary or a conservation reserve as a community reserve for protecting fauna, flora and traditional or cultural conservation values and practices. So, here again you will find traditional or cultural conservation values and practices. So, it is a voluntary activity and only those areas can be declared as community reserves that are private or community lands and are not comprised within a national park, sanctuary or a conservation reserve. And then the provisions of the sanctuary, they apply here as well. As before, we have a community reserve management committee, which is the authority responsible for conserving, maintaining and managing the community reserve. Now, in the case of a conservation reserve, the chief wildlife warden was the authority, but in the case of community reserve, the community reserve management committee is the authority responsible for everything because it's a private land. The committee shall consist of 5 representatives nominated by the village panchayat, or where such panchayat does not exist, by the members of the Gram Sabha, and 1 representative of the state forest or wildlife department under whose jurisdiction the community reserve is located. The committee shall be competent authority to prepare and implement the management plan for the community reserve and to take steps to ensure the protection of wildlife and its habitat in the reserve. So, the committee, the community reserve management committee, it is the competent authority to prepare and implement the management plan as well. So, what will be done in this community reserve, it is decided by the committee itself. Then section 38 says power of central government to declare areas as sanctuaries or national parks. So far we have seen that the state government has the power to declare the sanctuaries or national parks or community and conservation reserves. But section 38 says that the central government also has the power to declare areas as sanctuaries or national parks, in which situations where the state government leases or otherwise transfers any area under its control, not being an area within a sanctuary, to the central government. And the central government may, if it is satisfied that the conditions specified in section 18 are fulfilled, then the same processes will apply. Then chapter 4A deals with the central zoo authority and recognition of zoos. Now 4A means that this chapter was added later on through an amendment, and the sections here again will have the letters after the numbers. So we have a central zoo authority made by section 38A. The central government shall constitute a body to be known as the central zoo authority to exercise the powers conferred on and to perform the functions assigned to it under this act. It consists of a chairperson, members not exceeding 10, and a member secretary to be appointed by the central government. Then we have terms of office, conditions of service, functions of the authority. Now, why do we have the central zoo authority? It performs the following functions. It specifies the minimum standards for housing, upkeep and veterinary care of the animals kept in a zoo. So, if you have a zoo, then what are the minimum standards for housing? What is the size of the enclosure? How do you do an upkeep of the animals? At what times do you have veterinary care provided to the animals? What kinds of veterinary care? So, what are the minimum standards? All of those are set. Evaluate and assess the functioning of zoos. Recognize or de-recognize zoos. Identify endangered species of wild animals for the purpose of captive breeding and assigning responsibility in this regard to a zoo. Coordinate the acquisition, exchange and loaning of animals for breeding purposes. Ensure maintenance of stud books of endangered species of wild animals bred in captivity. Why do you have stud books? The stud books ensure that when captive breeding is going on, you do not breed between very close relatives. Identify priorities and themes with regard to display of captive animals in a zoo. So, for example, the CZA says that if you are displaying captive animals, you should not be displaying those captive animals that are diseased or that are maimed. For instance, if you have an animal that has lost a leg, it should not be used as a display animal. Coordinate training of zoo personnel in India and outside India. Coordinate research in captive breeding and educational programs for the purposes of zoos. Provide technical and other assistance to zoos for their proper management and development on scientific lines, and perform such other functions as may be necessary to carry out the purposes of this act with regard to zoos. Then there is the procedure to be regulated by the authority, when it should meet and so on. Then the act also talks about grants and loans to the authority and constitution of fund for their activities. So, because you have so many activities, for that you require grants and loans, you require money, and so there is a fund that is set up for the central zoo authority, and it may make use of the monies that are deposited there. Now, if there is a fund, there also has to be an annual report. So, the authority shall prepare in such form and at such time for each financial year as may be prescribed its annual report giving a full account of its activities during the previous financial year and forward a copy thereof to the central government. And this annual report and audit report are laid before the parliament. So, because there is a funding, there is a fund, so that fund has to be audited. So, the annual report and the audit report is laid before the parliament. It is before the eyes of the legislators. Then we have section 38H that talks about recognition of zoos. No zoo shall be operated without being recognized by the authority. Now, why is this recognition important? This recognition is important to ensure that the minimum standards are followed. If we did not have this process of recognition and derecognition, then zoos would not have any incentive to follow the minimum standards. And so, we have this provision of recognition of zoos. Acquisition of animals by a zoo. How does a zoo get animals? Subject to other provisions of this act, no zoo shall acquire, sell or transfer any wild animal or captive animal specified in schedules 1 and 2 except with the previous permission of the authority. And no zoo shall acquire, sell or transfer any wild or captive animal except from and to a recognized zoo. Meaning that one, a zoo can only get an animal from another zoo, and that zoo also has to be a recognized zoo. But here it says wild or captive animal. So, how does a zoo get a wild animal? A zoo gets a wild animal when the chief wildlife warden has stated that such and such animal is dangerous to human life, and because of that it will be hunted. And when we talk about hunting, it means that in this particular case it will be captured, it will be tranquilized or captured by say a physical means, and then it will be kept in a zoo because it cannot be rehabilitated into the wild conditions. So, for a zoo we cannot just go out in the forest areas, capture the animals and bring them to a zoo. That is not permitted. What is permitted is that you can use zoos as rescue centers for those animals that were dangerous to human life or to human property depending on the sections, and in place of killing those animals you can keep them in a zoo because they cannot be rehabilitated in the wild conditions. So, that is one way. The other way is that a zoo can get animals from other zoos, other recognized zoos, and getting these animals or giving these animals. So, acquisition, selling or transfer can only be done with the previous permission of the authority. So, a zoo cannot just take these decisions unilaterally, it has to take permission from the central zoo authority. Prohibition of teasing etc. in a zoo. So, no person shall tease, molest, injure or feed any animal or cause disturbance to the animals by noise or otherwise or litter the grounds in a zoo. So, if you visit any zoo, you will find these things written on different boards that you should not tease the animals, you should not molest the animals, you should not injure the animals, and most importantly you should not feed any animals, and you should not cause any disturbance to the animals by noise or otherwise. You should not litter the grounds in a zoo, and all of these are following from the Wildlife Protection Act. Then chapter 4B talks about the National Tiger Conservation Authority. Now, the NTCA or the National Tiger Conservation Authority is an authority constituted under section 38L of the Wildlife Protection Act, and this chapter begins with all these different definitions. Then 38L talks about the constitution of the NTCA. So, the central government shall constitute a body to be known as the NTCA to exercise the powers conferred on and to perform the functions assigned to it under the Act. Who are the members? The minister in charge of Ministry of Environment Forests is the chairperson. So, the minister is the chairperson. The Minister of State in MOEF and CC is the vice chairperson. So, both the ministers are members of this authority. 3 members of Parliament, of whom 2 shall be elected by the House of People and 1 by the Council of States. 8 experts, or professionals having prescribed qualifications and experience in conservation of wildlife, Secretary MOEF, Director General of Forests and Special Secretary, Director Wildlife Preservation, 6 Chief Wildlife Wardens from Tiger Reserve states in rotation for 3 years, an officer not below the rank of Joint Secretary and Legislative Council from the Ministry of Law and Justice, Secretary, Ministry of Tribal Affairs, Secretary, Ministry of Social Justice and Empowerment, Chairperson, National Commission for the Scheduled Tribes, Chairperson, National Commission for the Scheduled Castes, Secretary, Ministry of Panchayati Raj, and Inspector General of Forests or an officer of the equivalent rank having at least 10 years experience in a tiger reserve or wildlife management, who shall be the member secretary. So, here as well we find that a very large number of people are there in the NTCA. They come from different fields, they come from different ministries. Why? Because the NTCA has to take decisions on matters that concern a large number of people. So, if you are doing tiger conservation, you also need to ensure that the rights of the scheduled tribes do not get negatively impacted. So, for that you have a representative of the Ministry of Tribal Affairs. You need to ensure that whatever we are doing for the conservation of tigers is not against the people of India, and for that, to ensure that we have legislators that are coming from the parliament and so on. You need to have experts to ensure that we are taking the right decisions for tigers. You have chief wildlife wardens of different tiger states, because they know about what are the policy lacunae that are there in the field and what needs to be improved. So, all of these people are brought together in the form of the NTCA. Then we have terms of office and condition of service of the members, officers and employees of the NTCA, powers and functions of the NTCA. Now, this powers and functions becomes important. What does the NTCA do? Why do we have so many people here? It has the following powers and performs the following functions: to approve the tiger conservation plan prepared by the state government under subsection 3 of section 38V of the Act. So, section 38V says that there will be a tiger conservation plan. So, you cannot just go about doing anything, you need to write it down, you need to make a plan what you want to do, and that plan will be approved by the NTCA. Evaluate and assess various aspects of sustainable ecology and disallow any ecological unsustainable land use. Lay down normative standards for tourism, provide for management focus, provide information on protection measures, approve, coordinate research and monitoring, ensure that the tiger reserves and areas linking one protected area or tiger reserve with another protected area or tiger reserve are not diverted for ecologically unsustainable uses, except in public interest and with the approval of the National Board of Wildlife and on the advice of the Tiger Conservation Authority. Now, this is a very important section. What it is saying is that the powers of the NTCA are not just confined to the tiger reserves, but they also fall in the areas that are linking one protected area or tiger reserve with another protected area or tiger reserve. Because animals naturally migrate from one place to another, and so the NTCA also ensures that the areas that are linking one protected area or tiger reserve with another protected area or tiger reserve, they are not being used for in the form of ecologically unsustainable uses, so that the animals are able to migrate from one place to another, because that's a natural process that is essential for the conservation of animals. Facilitate and support the tiger reserve management and so on. And then section 3802 becomes important. The Tiger Conservation Authority may, in the exercise of its powers and performance of its functions under this chapter, issue directions in writing to any person, officer or authority. So, it has rights over all the people of India. It can write to any person for the protection of tiger reserves, and such person, officer or authority shall be bound to comply with the directions, provided that no direction shall interfere with or affect the rights of local people, particularly the scheduled tribes. So, there is also a saving provision. Then we have procedure to be regulated by the NTCA, grants and loans to the Tiger Conservation Authority and constitution of fund. So, as in the case of CZA, we also have a fund for the NTCA. Then now, if there is a fund, there will be accounts and audit. And then there is an annual report, and this annual report is also laid before the parliament, as is the audit report. So, the parliament has a control over everything. Then there is also a steering committee and a tiger conservation plan. So, the state government shall, on the recommendations of the Tiger Conservation Authority, notify an area as a tiger reserve. So, here we are talking about tiger reserves, and the tiger reserve comprises of two areas. The expression tiger reserve includes the core or critical tiger habitat areas of national parks and sanctuaries. So, these are known as the core areas, and you also have buffer or peripheral area consisting of the area peripheral to the critical tiger habitat or core area. Now, why do we need both of these areas? The core area is primarily for the animal. So, it is a habitat of the animal. The animals live in the core area. But then if you have a high density of wild animals, and right outside the core, if you have human habitations, then there is a good chance that the animals will venture into the human habitations, or humans will venture into the animal habitations. And so there can be a situation of conflict. So what is done to alleviate this problem is that you maintain a core area that has all the good conditions for the animals, and then around the core areas you maintain a buffer area. Now, the buffer area will have a shortage of food supply, it will have a shortage of water supply, there will be a shortage of prey population, and so the animals will not like to live in the buffer area. And so the animal density is very less. And so you will not have situations where the animals are routinely moving into the agricultural fields. And similarly, if somebody wants to enter into the core area, he or she will have to pass through the buffer area. And in that situation, he or she will not find a large number of animals there. And so the chances of hunting or poaching of animals, it also goes down. Now, so the Wildlife Protection Act demarcates that there will be core areas and buffer or peripheral areas in the case of tiger reserves. Then alteration and denotification of tiger reserve. No alteration in the boundaries of a tiger reserve shall be made except on a recommendation of the Tiger Conservation Authority and the approval of the National Board of Wildlife. And no state government shall denotify a tiger reserve except in public interest with the approval of the NTCA and the National Board of Wildlife. Then we have establishment of a Tiger Conservation Foundation for every state. Then chapter 4C talks about Tiger and Other Endangered Species Crime Control Bureau, which is now known as the Wildlife Crime Control Bureau, WCCB. So it talks about constitution of this bureau, and it has these members: the Director of Wildlife Preservation, IG of Police, Deputy Inspector General of Police, Deputy Inspector General of Forest, Additional Commissioner, and so on. And then it defines the powers and functions. Then chapter 5 deals with trade or commerce in wild animals, animal articles and trophies. Wild animals, etc. to be government property. So wild animals are government property, and it includes everything. So every wild animal other than vermin which is hunted becomes a government property. Every animal article, trophy or uncured trophy that is derived without following the rules and by doing an offence, it becomes a government property. Every ivory imported into India, an article made in respect of which any offence has been made, becomes a government property. The vehicles, vessels, weapons, traps or tools that have been used to commit an offence, they become government properties, and so on. Now it talks about declaration. So every person having at the commencement of this act the control, custody or possession of any captive animal specified in Schedule 1 or Part 2 of Schedule 2, or animal article, trophy or uncured trophy derived from such animal, or salted or dried skins of such animal, or the musk of a musk deer or the horn of a rhinoceros, shall within 30 days from the commencement of this act declare to the Chief Wildlife Warden or the authorized officer the number and description of the animal or article of the foregoing description under his control, custody or possession and the place where such animal or article is kept. So, if you have any of these, they have to be declared within 30 days of the commencement of the Wildlife Protection Act. But then because people did not declare it, so government also gave an immunity for certain other period, so that people are able to declare it. So, this is the immunity in those cases. Then it talks about inquiry and preparation of inventories, certificate of ownership, regulation of transfer of animal, dealings in trophies and animal articles without license, suspension or cancellation of licenses, the procedure of appeal, maintenance of records, purchase of animals, restriction on the transportation of wildlife, purchase of captive animal. So, basically what this chapter is talking about is that the wild animals or captive animals or trophies made out of them, whether they are processed trophies or unprocessed trophies. So, when this act was commenced, all of these things had to be noted down, they had to be told to the Chief Wildlife Warden that I have such and such things, because after this act, getting of these animals or captive animals or these trophies, it was outlawed, except while following certain procedures. So, you need to tell the government about the initial stock, and if you are procuring anything, then it has to be done through a license, so that the records are maintained and people are not able to kill the animals and make trophies out of them. So, this is a provision to conserve the animals. Then chapter 5A, prohibition of trade or commerce in trophies, animal articles, etc. derived from certain animals. So, chapter 5A, as the name suggests, it was included later on. So, it talks about scheduled animal article. Now, in the case of scheduled animal article, it means an article made from any scheduled animal, where scheduled animal means being a part of schedule 1 or part 2 of schedule 2. So, schedule 3 and 4 animals are not included here. So, scheduled animal article means an article made from any scheduled animal and includes an article or object in which the whole or any part of such animal has been used, but does not include tail feather of peacock, an article or trophy made therefrom, and snake venom or its derivative. So, these are excluded from the definition of scheduled animal article. Then we have section 49B, prohibition of dealing in trophies, animal articles, etc. derived from scheduled animals, declaration by dealers. Then chapter 6 deals with prevention and detection of offences. So, if you have all these offences that have been defined, all these different penalties that have been defined in the act, so how do you go about finding out if an offence has been done, is what this chapter is dealing with. Prevention and detection of offences. So, it gives the forest officers certain powers: power of entry, power of search, power of arrest, and power of detention. So, notwithstanding anything contained in any other law for the time being in force, the director or any other officer authorized by him in this behalf, or the Chief Wildlife Warden or the authorized officer or any forest officer or any police officer not below the rank of sub-inspector may, if he has reasonable grounds for believing that any person has committed an offence, require any such person to produce for inspection any captive animal, wild animal, animal article, meat, trophy, uncured trophy, specified plant, and so on, or any license, permit, or other document granted to him and required to be kept by him under the provisions of this act. Then the person can also stop any vehicle or vessel in order to conduct search or inquiry, enter upon and search any premises, land, vehicle, vessel in the occupation of such person, open and search any baggage or other things in his possession, and then seize those articles, seize the captive animal, wild animal, animal article, meat, and so on. And it shall be lawful for any of the officers referred to in subsection 1 to stop and detain any person whom he sees doing any act for which a license or permit is required for the purposes of requiring such person to produce the license, and so on. And as the case may be, he may be arrested without warrant. When it says arrested without warrant, what does it mean? It means that all the offences in the Wildlife Protection Act have been made into cognizable offences. We saw before that cognizable offence is an offence for which there can be an arrest without warrant, and this section is saying that in all these cases the person may be arrested without warrant. So, all the offences in the Wildlife Protection Act are cognizable offences. Then any officer of a rank not inferior may give the same for custody on the execution by any person of a bond for the production of such animal. The person detained or things seized under the foregoing power shall forthwith be taken before a magistrate to be dealt with according to the law, under intimation to the chief wildlife warden or the officer authorized, and so on. So, these are the various powers that are given to the forest officers. Then section 51 talks about penalties. So, we have defined offences. Now, what are the penalties for any person who does these offences? So, any person who contravenes any provision of this act except chapter 5A and section 38J or any rule or order made thereunder, or who commits a breach of any of the conditions of any license, shall be guilty of an offence under the act and shall on conviction be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 25,000 rupees or both. So, here the incarceration can go up to 3 years, provided that where the offence committed is in relation to any animal specified in schedule 1 or part 2 of schedule 2, or the meat of any such animal or animal article, trophy or uncured trophy derived from such animal, or where the offence relates to hunting in a sanctuary or a national park or altering the boundaries of a sanctuary or a national park, such offence shall be punishable with imprisonment for a term which shall not be less than 3 years, but may extend to 7 years. So, the minimum punishment for doing any of these things is 3 years of incarceration, but it may also extend to 7 years. Provided further that in the case of a second or subsequent offence of the nature mentioned in this subsection, the term of imprisonment shall not be less than 3 years, but may extend to 7 years, and also with fine which shall not be less than 25,000 rupees. So, in this instance the fine was not less than 10,000, here the minimum fine has also been extended to 25,000 rupees. Any person who contravenes any provisions of chapter 5A shall be imprisonment for a term which shall not be less than 3 years. So, we had seen before that chapter 5A and section 38J were excluded. So, in the case of chapter 5A, the imprisonment is not going to be less than 3 years and may extend to 7 years, and a fine which is not less than 10,000 rupees. And for contravention of 38J, imprisonment which may extend to 6 months or with fine which may extend to 2,000 rupees or both. So, we are finding that the provisions here are fairly stringent. Certain conditions to apply when granting bail, attempts and abatement. So, this section 52 says that whoever attempts to contravene or abets the contravention of any of the provisions of this act or any rule or order made thereunder shall be deemed to have contravened the provision of or rule or order as the case may be. So, the punishment for attempt and abatement is the same as the punishment for the commission of the offence. Then it talks about punishment for wrongful seizure, power to compound offences, cognizance of offences. So, no court shall take cognizance of any offence against this act except on the complaint of any person other than the Director of Wildlife Preservation, Member Secretary CZA, Member Secretary NTCA, Director of the concerned Tiger Reserve, or the Chief Wildlife Warden or any authorized officer in this behalf. The officer in charge of the zoo, and any person who has given notice of not less than 60 days in the manner prescribed of the alleged offence and of his intention to make a complaint. So, any citizen or any person can also file a case in the court, but this procedure has to be followed of giving a notice. Operation of other laws not barred, presumption to be made in certain cases. Now, this is important. Where in any prosecution for an offence under this act, it is established that a person is in possession custody or control of any captive animal, animal article, meat, trophy, uncured trophy, specified plant or part or derivative thereof, it shall be presumed and it shall be presumed. So, we have seen before in the case of Indian Evidence Act, what does it mean? It shall be presumed means that it must be presumed. The court does not have any other option. Until the contrary is proved, the burden of proving which shall lie on the accused, that such person is in unlawful possession, custody or control. So, if somebody is found in possession, custody or control, it is presumed that the possession, custody or control is unlawful until and unless the contrary is proved, and the burden of proving the contrary, it lies on the accused. So, in this case, the situation is not innocent until proven guilty, the situation is guilty until proven innocent. Now, why have these provisions been made so stringent? They have been made so stringent because when we talk about wildlife, when we talk about forest areas, you will not have a large number of humans in those areas. And so, the amount of evidence is going to be very less. So, if you want to protect the wild animals, you have to make very stringent rules. So, here is a difference that we are finding as compared to the other acts. Then, in the case of offences by companies, the head of the company and other people who were involved, they become liable and so on. Then chapter 6a talks about forfeiture of property derived from illegal hunting and trade. And we have seen before that in our country, absolute forfeiture is not a punishment, but forfeiture of certain specified things is included as a punishment. And in this case, we are talking about forfeiture of property that is derived from illegal hunting and trade. So, if somebody is making money, is making property from illegal hunting and trade, so all that property will be forfeited to the government. So, it applies to these situations. Then we have appellate tribunals and so on, prohibition of holding illegally acquired property, competent authority identifying such property, seizure or freezing of illegally acquired property, management of properties seized or forfeited under this chapter, notice of forfeiture, forfeiture of property in certain cases, burden of proof. Now, here as well you will find in any proceedings under this chapter, the burden of proving that any property specified on in the notice served under section 58H is not illegally acquired property shall be on the person affected. Meaning that if somebody has been convicted of wildlife offense, if you have found that this particular person is dealing with tiger skin or is dealing with ivory or other animal articles, and you find that this person has a lot of property, then all of that property can be forfeited to the government unless it is proven that that property was not derived out of the illegal trade. And the burden of proving that lies on the accused, not on the government. So, here as well we find that the presumption is guilty until proven innocent. And so, the provisions are fairly stringent. Then fine in lieu of forfeiture, procedure in relation to trust properties, certain transfers to be null and void. So, if the person tries to transfer the property to someone else, then that transfer becomes null and void. Constitution of an appellate tribunal to hear the appeals. Then we have a section on appeals, notice or order not to be invalid for error in description, bar of jurisdiction. So, no order passed or declaration made under this chapter shall be appealable except as provided therein, and no civil court shall have jurisdiction in respect of any matter which the appellate tribunal or any competent authority is empowered by or under this chapter to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this chapter. So, it bars the jurisdiction of different courts. So, it says that only these courts and appellate authorities will have power, not the other courts. Competent authority and appellate tribunal to have powers of a civil court, meaning that they can summon the enforcement and attendance of any person, examine him on oath, require the discovery and production of documents, receive evidence on affidavit, requisition any public record or copy thereof from any court or office, issue commissions for examination of witnesses and documents, and any other matter which may be prescribed. So, all of these powers are there with the competent authority and the appellate tribunal. Then we have information to competent authority, certain officers to assist the administrator, competent authority or appellate tribunal, power to take possession, rectification of mistakes, findings under other laws not conclusive for proceedings under this chapter, service of notice and order, punishment for acquiring property in relation to which proceedings have been taken under this chapter. So, all of these things are there in the Act. Then we have the miscellaneous provisions. So, one of those is that the officers to be public servants. So, every officer referred to in chapter 2 and the chairperson, members, member secretary and other officers and employees referred to in chapter 4A, 4B and every other officer exercising any of the powers conferred by this Act shall be deemed to be a public servant within the meaning of section 21 of the IPC. Then there is protection of action taken in good faith. So, you need to protect the officers who are taking action in good faith. Reward to persons. So, when a court imposes a sentence of fine or a sentence of which fine forms a part, the court may, when passing judgment, order that the reward be paid to a person who renders assistance in the detection of the offence or the apprehension of the offenders out of the proceeds of fine not exceeding 50% of such fine. So, the court has the power to reward the persons who have aided in the detection of the offence and apprehension of the offenders out of the fine that is taken from the offender. And similarly, we have reward to persons clause when cases are compounded. Then we have reward by the state government, power to alter entries in schedules. So, who can change the schedules? Only the central government, not the state government. The central government may, if it is of opinion that it is expedient to do so, by notification add or delete any entry to or from any schedule or transfer any entry from one part of a schedule to another part of the same schedule or from one schedule to another. On the issue of notification under subsection 1, the relevant schedule shall be deemed to be altered accordingly, provided that every such alteration shall be without prejudice to anything done or omitted to be done before such alteration. So, the central government has the power, and when it does it by notification, then the alteration is made, but anything done before the alteration is not changed. Declaration of certain wild animals to be vermin. Who can declare animals to be vermin? Only the central government. The central government may by notification declare any wild animal other than those specified in schedule 1 and part 2 of schedule 2. So, these animals cannot be declared as vermins, and the declaration is done for a fixed area and for such period. Then we have power of central government to make rules for different things, and these rules are laid before the parliament. Then we have power of the state government to make rules, rights of scheduled tribes to be protected, repeal and savings. So, the previous acts become repealed, but the important thing here is, for the removal of doubts, it is hereby declared that any sanctuary or national park declared by a state government under any act repealed under subsection 1 shall be deemed to be a sanctuary or a national park, as the case may be, declared by the state government under this act. So, any national park or sanctuary that was declared before will be deemed to be a sanctuary or a national park under this act as well. And where any right in or over any land in such national park which has not been extinguished under the said act at or before the commencement of this act, the extinguishment of such rights shall be made in accordance with the provisions of this act. So, if the rights have not been extinguished, then the extinguishment of the rights have to be done as per the provisions of this act. And for the removal of doubts, it is hereby further declared that where any proceeding under any provision of sections 19 to 25 is pending on the date of commencement of the Wildlife Protection Amendment Act, any reserve forest or any part of territorial waters comprised within a sanctuary declared under section 18 to be a sanctuary before the date of commencement shall be deemed to be a sanctuary declared under section 26A. Why? Because this section was later on added through the Wildlife Protection Act Amendment Act 1991. And so anything that was done before that will be deemed to be a sanctuary or a national park, is what these sections are saying. So that's all for today. Thank you for your attention. Jai Hind.